Hello, everybody, and welcome back to the final panel session, panel 7 of a jam-packed day of insights and expertise across a whole range of topics. We've heard about tackling global challenges together from secretaries of state, former heads of state, diplomats, and we've heard about artificial intelligence and real applications from the European Commission, the European Parliament, from Workday, from Deloitte. And we've heard about navigating trust and risk from a whole range of experts from national governments, European Parliament, the European Law Institute. We've heard about competition and innovation. Again, experts from Deloitte, the University of Oxford, speaking alongside national regulatory bodies there. The perils and potential of digital currencies, fascinating panel discussion there, all about central bank digital currencies. And the last panel, which I moderated moments ago, hope you enjoyed that. That was all about personalization and fairness in the modern data ecosystem. So with experts from Meta, Deloitte, alongside the Data Protection Commission of Ireland. So we've covered a lot of ground, and we're on the final furlong, back to sort of where we started in a way, which is about how different jurisdictions can work together. The theme of the conference is all about building bridges, bridging parallel lines. So the theme of this panel is bridging privacy, security, and borders. We've talked quite a bit about sort of personal privacy in previous panels. This is more to do with about privacy, but how that links to sort of national security and data flows across borders. So delighted to be joined by a fantastic panel of experts who I will hand over to our brilliant moderator, Professor Mira Burri, who's the Professor of International Economic and Internet Law at the University of Lucerne. Mira, over to you to introduce our panel of experts. Thank you, Mira.
Thanks so much, Ben, and good afternoon or good morning to all of you. I'm delighted to moderate this panel on bridging privacy, security, and borders. We do have, as Ben mentioned, a panel of distinguished experts on board, starting with Bojana Bellamy, President of the Center for Information Policy Leadership, amongst others, Alison Tilley, Commissioner with the South African Information Regulator, Katherine Harman-Stokes, Acting Director of the Office of Privacy and Civil Liberties with the US Department of Justice, Nele, a Data Reuse Program Manager with the Estonian Ministry of Economic Affairs and Communications, and last but not least, we also have Sam Roberts on board, who is Head of Data Bridges and Mechanisms with the UK Department for Science, Innovation and Technology. So you see already from this list that not only we have a lot of expertise on board, but also representatives of different countries and different perspectives, coming from government, from state agencies, from developed as well as developing countries, as well as industry. So I trust the conversation that we are going to have today will be interesting to many of you and give important insights into this highly dynamic field of data governance that we have with this key topic of cross-border data flows and how it can be interfaced with domestic, in particular, data protection regimes. So I would like to start the conversation with a question to everyone. A rather general introductory question about how we can navigate this evolving and, as I mentioned, very dynamic landscape of data privacy laws around the world with the GDPR, but also beyond it. And perhaps a more sort of zooming question, what is from your perspective, the most significant development in this field that we have seen in recent years? And I will give the floor to everyone, and I suggest that we follow the sequence of speakers that we have announced in the program. So we start with Bojana and then go to Alison, Kathy, Nele, and finally Sam. Yes, please, the floor is yours.
Thank you, Mira, very much. And hello, everybody from sunny London. So let me immediately address your question, what I think is two of the most important developments in this complex digital and data world. I would say one, the realization that in fact, data is an essential asset for progress, innovation, prosperity for both governments and private sector as well. It brings huge benefits to everybody, the ability to use data, to have access to data. But on the other hand, we also have got this, what I call sometimes schizophrenic point of view of data, because data brings risks. Data brings compliance issues. Data is heavily regulated by fragmented set of rules. Data can be lost and misused. So we have this need to use and have more data, but on the other hand, the need to protect and manage data responsibly. And so what I think has happened is that this realization is starting to hit everybody. And this requires a really different thinking by everybody. It requires, first of all, governments and law and policymakers to consider how do they think about this holistic data strategy. It can't be just protection of privacy and data protection. It has to be also enablement of data use and innovative data use and responsible data use, right? So governments have to think about this. Equally, organizations, public and private sector organizations, they have to think about how are they able to use data. And, I do not believe that data is new oil. I think that's a really bad metaphor. I think data is almost like environmental protection. We need to make sure we have it in the system. We need to make sure we have fair access to it. We need to make sure that it's nurtured, it's protected, but everybody can also benefit from it. And I think that realization is something that has changed a lot. Today, we don't have good tools, Mira, right? We have got tools to measure privacy risks. We have got privacy rules, but we haven't got tools and assessments that actually look into this holistic view of data. So it's not just about protecting privacy, but it's also, on the other hand, ensuring cybersecurity. It's not about protecting privacy only, it's also ensuring fair competition and access to data. We are seeing also these tensions between how AI technology is developed, how privacy rules are being created as well. Even in children's protection, we need to ensure children are protected online, but also they have got access to information, education, and are able to benefit from everything that this digital world brings them. So we need really new tools and rule books, I think, to actually deal in this new world. Last point is that big development for me also in the past year has been the realization by companies that they have to be seen as accountable businesses that are responsible stewards and responsible users of data. And I know you wouldn't think so because people look at media, there is always some negative, but I work with lots of multinational companies and I see how much investment and effort has gone into ensuring responsible data use. And now with the sort of this frog leap of AI technologies and some other emerging technologies, how are they also responsible developers, deployers of AI and other technologies as well? And that organizational accountability, so how do you build programs, policies, procedures, culture, tools, technologies to help deliver that responsibility? And how do you demonstrate that internally to your leadership, to your C-suite, your board, but also to regulators, I think, and customers? I think that's going to be really the big driver. And I really hope that we're going to be focusing more on that as well.
Thank you so much. I think you set the backdrop really in an excellent way, like that we should not focus only on sort of the risks that are linked to data use and reuse and collection, but also to focus on the benefits that we have for the economy, but also for society as a whole in very different facets. And I quite like your comparison with environmental protection. I think it's very fitting. But I give the word to Alison to give us maybe the perspective from South Africa.
Well, I think the most important development in South Africa has been the data protection legislation actually coming into operation and the information regulator being established. The regulator has only in the last 2 or 3 weeks handed down its first decisions in terms of our Protection of Personal Information Act. So for us, I think, and just to give you a sense of that, that was a a case concerning a WhatsApp message listing the names, addresses, and contact details of a number of survivors of sexual assault. A WhatsApp with the list of names in being released by the police in such a way that they became, a message that was just spread virally across the country. So, I think we're kind of at the beginning. Our legislation is really quite heavily reliant on the GDPR for its framework, and I think we paid attention to that as something that helped guide us in terms of legislation, which was only actually passed by Parliament in 2013. We've come to the question of cross-border flows. We haven't had to make any decisions in relation to those. What we do know at this point is that we are not going to develop a whitelist. Some of the other jurisdictions in Africa have made the decision to do that. We are concerned about the idea of making findings around adequacy simply because the environment changes so quickly, and a jurisdiction which may be adequate in one respect in 1 year, that could well change in the next year. So I think we're still very much finding our feet in terms of cross-border flows. Certainly, I think we're going to have to look at all of the different mechanisms that we use to safeguard data when it moves across borders. I was just listening to the conversation earlier. We do, in fact, somewhat presciently have a provision in our legislation around automated decision making, and I particularly like the description somebody used of having a human in the loop, which is more or less what our section does. But I think we have to recognize that a large part of our legislation really, 2012, 2013 was a sort of polishing it in Parliament. The most of the drafting is now 10 years old. It took a long time to get the legislation in place, but I think, certainly discussions like this help us think about how we need to develop our legislation, and indeed how we need to make our decisions going forward. We'll obviously be looking to other jurisdictions for their experience and how they've made the decisions on those issues.
Thank you so much, Alison. I think it's very interesting. We do focus very often simply on the US-EU sort of divide or convergence, and then completely forget that data governance development happens around the world and very often at very different speeds. So thank you, and I give the word now to Katherine.
Thank you. Thank you for having me, inviting me to speak here. The most significant development that I'm seeing is the true focus on data protection and privacy in multiple forums around the world. We have a shared commitment to upholding democracy and the rule of law and protecting privacy and other human rights and fundamental freedoms. Existing safeguards, while not identical, are founded upon the same principles that reflect the shared commitment to democracy and rule of law. We're collectively identifying the commonalities in these different legal frameworks, and while they may be applied slightly differently in different legal and historical contexts, they are founded on the same principles and same concepts. So we're seeing privacy and data protection come up in the UN Human Rights Council, in the Freedom Online Coalition, the G20, the G7 ministers, but also we now have the G7 Data Protection Authority Roundtable that's meeting regularly and putting out a lot of good work and statements on privacy issues. Japan is still advancing and pushing forward on its data free flow with trust, and it's advancing well, I think, in these different forums. We have the US-EU Trade and Technology Council, and we also have two really big successes in bridging the different legal frameworks. OECD adopted a declaration in December that sets forth common principles on government access to data held by the private sector. And they used an excellent approach in coming up with those principles. They got the law enforcement and national security experts in the same room with the privacy experts. And then they were able to work out and identify the commonalities and agree on those core principles. Also, you have the Cybercrime Convention from the Council of Europe, the Budapest Convention. It adopted the second additional protocol, and that protocol used the same sort of approach. You had data protection authorities in the room with law enforcement authorities, and we were able to identify and document the common principles and what the protections are going to be in the data that is accessed by law enforcement. I do think it's critical, as has been said, that we consider the data privacy and data protection privacy issues alongside the other interests. I think Japan's message about data free flow with trust in trying to advance economic development and advance our societies while also at the same time protecting privacy and protecting personal data. So I think we really need these types of efforts to continue to identify the commonalities that we have in our frameworks and move toward what a lot of people are calling convergence. I think I'm optimistic about where that's going and building bridges between different frameworks. Thank you.
Thank you, Katie. I think it's important to highlight the increasing commonalities and that we are taking sometimes baby, sometimes bigger steps into the right direction. And I quite like what you mentioned, that it's important to bridge silos, to break silos and to bridge the different communities, be it the privacy community together with, the trade community, and then with cybersecurity and national security communities. So thank you. And I give now the word to Nele.
Hi, it's nice to be here. I agree and disagree with Bojana. Maybe it's the data is not the new oil, but I would say that this is advantage. With data, you are more competitive maybe for the next decades, as says European data strategy. And if you ask that, what would be the main direction concern of recent times, I would say that the growth of data and technology that allows to collect and process the data so easily. Just to be clear and to underline, I'm not against the data and I'm not against the processing of the data, but it should be processed in transparent manner. Maybe it's more visible way. So I think that the same technology, we are afraid of the AIs, but with the technology we can enable the same technology that collects the data. I think that the same technology can help us to make possible to do it in more transparent or visible ways. So I think that I am a believer of techniques, so and other measures, not just the norms or principles. So how we are using PETs, privacy technologies, are we using them? I think that we should move toward with human-centric data governance, and in Estonia we are doing it right now. And maybe after I can give some examples of that. Thank you.
Thank you. I think you actually are not in complete disagreement with Bojana was saying, because she also highlighted that data is an asset. But with the oil comparison, there are all those things about like being an exhaustive resource, not being able to reuse it. So I think we're actually quite in agreement. And we'll be coming back to this question, whether and how technology can help us, perhaps politicians are failing now. So some maybe can follow up on this.
Thank you. Yeah, I can't speak for politicians, but I can certainly give you my view as a policymaker. I think first of all, it's kind of important to I think reflect on what's been said already on this panel. There has been an unbelievable pace to the change of technology over the last few years. If you'd asked me this question a year ago, I may have pointed to the advent of machine learning as a huge kind of boost in the way that technology is operating. Previously to that, I could have said social media. At the moment, we're talking about AI, and I think it's very kind of important to recognize the pace at which kind of technology is evolving is outstripping the kind of pace of, shall we say, legal protection and things of that nature. We're having to effectively kind of retrofit kind of frameworks around technologies and innovations that are really kind of not fit for purpose in that respect. And so we're doing our best, I think, to keep pace. And so I think I'm really kind of happy to have heard already on this panel mentions of things like the OECD around kind of collaboration between various countries around how to kind of, I guess, police the way that data is being used, the way that private data is being shared and kind of communicated between borders. Because I think that that's really the key thing here is around kind of where the laws are still kind of racing to keep pace with the technology that we're seeing. We're having to think about things in a more kind of light touch way, and how do we do that? And I think my previous panelist there mentioned the idea of privacy enhancing technologies. I think that's a huge kind of leap forward in terms of thinking around how we try and protect people in a way that's kind of fit for purpose and proactive. And I also wanted to kind of call out the idea of there's various kind of programs happening internationally around things like, for instance, CBPR's, OECD recommendations, etc., that are really kind of helping bring that thinking forward around how do we create a framework that's fit for purpose and that can scale with this new technology that we're seeing evolving all the time. So I think from my perspective, that's really important. I think, it's also kind of worth mentioning this desirability point, which has also been raised a few times, which is that we need to be thinking about this in a more holistic manner as well. So we're not just looking at the risk, but we're also looking at the potential benefits of these technologies. And I think from a government perspective, from a policy perspective, we're constantly trying to bring the thinking back to the kind of what are the benefits, what are the potentials, what's the innovation that we can unlock by getting these other things right. And I think that a combination of the kind of legal frameworks and the mandation alongside these kind of softer, lighter touch interventions is the way we need to go in terms of bridging that gap.
Thank you. Sam, I think with all these inputs, we set the backdrop for more concrete questions really nicely. And linking to the first question about how to navigate the landscape, I have a more sort of concrete one. It was mentioned by several of you already that what we see are some convergences, but also a lot of divergences in the chosen models, in particular for cross-border data flows, which of course reflect what we have in domestic regimes, personal data, national security, and other issues. So it would be interesting, I think, to know whether you have thought of ways, mechanisms of how to bridge this divide so as to enable the safe transfer of data across borders, in particular in this time of geopolitical tensions that we have. And do you see any particular mechanisms that we can use that are viable already now, or do you think that they will be available going forward? And I'll suggest we go again in the order of the speakers.
Okay, then I will start on this one, and I'm also happy to sort of respond to some of the other points, but let me answer your question, Mira. Data flows are one of the top compliance but also risk and business issues for companies globally. From SMEs to large multinationals, everybody's grappling with this with the point, how are we able to share data across our own global company, with our partners, with third-party service providers, cloud providers, IT technologies? How are we able to, for example, bring data that we need to train this AI algorithms in a way that is fair, that is diverse, that is representative? And I've been in this field for so many years, and I always say this, it's probably one of the first things I did as a professional and lawyer working in privacy. And, so many years later, we're still grappling with this. So I think we have got to look for some short-term solutions and some perhaps medium-term solutions. I think short-term solutions certainly are to focus on what we have in common versus what we don't have in common. And so there are so many countries that actually have got, I think Alison has mentioned this, and Sam will know this from his work in the UK, so many countries who have got these adequacy findings. So I would perhaps urge everybody to rethink how we make these decisions, because one-to-one bilateral decisions, which take years to make, is just not agile enough for this new world. So how can we make these decisions in a more nimble, more agile way? This is very important. You know, we are regulating technology and data, which is incredibly agile, which keeps transforming all the time. And we can't do this through old-fashioned analog laws and tools and approaches. The second thing about short term is we have got lots of countries are requiring so-called contracts, standard contractual clauses, which companies can use to frame data flows between country A and B. And so at the moment, we've got an increasing number of countries having their own standard clauses. And so if you're a multinational organization, or if you are even one single small company that has got data from multiple sources, you would have to think about from Brazil to EU to ASEAN, New Zealand, China, you would have to incorporate UK, all of these standard clauses. So why can't we agree that between these like-minded countries, we will recognize each other standard contractual clauses, and we don't need to non-stop reinvent yet another standard, which is just a little bit different than the existing one? Can't we just agree that what we have is good enough and we can use it reciprocally? And similarly, binding corporate rules. Again, those of you who follow this very much legally, binding corporate rules are internal codes of conduct by which multinational companies apply the same high level of privacy protection everywhere in the world for all of its companies, no matter where they operate. So even if you have a company in Vietnam where there is no data protection law, for example, and South Africa where there is data protection law, in Europe, you would apply the same reasonably high level of privacy protection that we have in South Africa and Europe for all these other data flows. And that's a great way to achieve convergence, to build up the level of protection. But very importantly, the BCR is a very cumbersome mechanism. There are only 100 companies so far in 15 years that have actually got these approvals by regulators. So again, we need to streamline the approval process. We need to also enable, if I am BCR approved company, you are BCR approved, we should also be able to share data, because we are seen as trusted, accountable organizations. Now, medium term, I think we have to look else. We have to be brave and bold and look for multilateral arrangements for data transfers. So I'm incredibly optimistic and pleased to see that Global CBPR Forum has raised from the ashes, if you like, and is establishing itself as a potential way forward. That doesn't need to mean that it will be exactly this way. The CBPR forum also and the rules may need to evolve in order to bridge with other regimes, such as GDPR, and other countries need to recognize the CBPR as a potential model. But if we work together, as many of panelists have said, we actually have got a very good system that is based on CBPR, providing a high level minimum of, well, it's not just minimum, it's actually high level of common protection, and then certifiable by third parties, not the regulators, third parties. And once we comply with that, we can then share data multiple jurisdictions. To me, that's a really positive development. We need to work together to build on that, to upgrade so everybody can use it. Finally, there was lots of discussion about the OECD principles for government access to data. This is very important because, of course, one of the big obstacles to data flows is this fear of foreign governments using data and having access to this data in a way that doesn't comply with the law of the country from which data is exported. Again, you know, we have got much more in common than puts us apart. Security, national security, the need to protect people and property is a common shared ground. And I think there has to be some understanding that some government use of data is necessary as long as it's done in accordance with these principles, responsibly and accountably. And as long as companies share data accountably and data is used accountably, that's good enough. So that kind of discussion needs to happen now as well, because it has become part of the commercial data flows as well. And to some extent, it's really making it very, very difficult for any company, any medium-sized organization to comply by assessing the level of protection in a third country. So we do need some shortcuts and some agreements at multilateral level.
Thank you so much, Bojana. A lot of takeaways for me, and I believe also for the audience. I quite liked the need for international cooperation, as well as that you highlighted this regulatory burden that we have for companies that sometimes gets forgotten. But I hand over now to Alison.
Well, I've for much of my career, I've had one foot in civil society, and the other foot in government processes as part of the regulator now. I can see why structurally there is it's a sticky problem, because the data protection agencies are the ones who really are wrestling with these issues, certainly from my perspective. But of course, we have no power to change legislation, and certainly, no basis on which to engage in a multilateral institutions and agree to changes which would affect domestic legislation. So that's simply not within our powers. When business comes knocking on the door of government and on the door of Parliament in particular, and say that they need regulatory change, I think that's often heard by governments as meaning we want lower standards of protection. And whether that's true or not is something else. But I think that is certainly what governments hear from my perspective. And governments are involved in a lot of different burning issues, and it's I'm a privacy geek. I think it's enormously important. But if I look at the issues that my country is facing, they are many and varied, and just to get this on the agenda would take quite a concerted effort from civil society and business and the regulators. And I think that would also be the case internationally. So there is, I think, scope for and whoever is placed to do it in the way that they best can. The idea of creating more organizing and more discussion about how to develop international standards. I think they are there in a nascent form in a number of different places, but certainly from my perspective, it took certainly from when the initial instruction went to the Law Reform Commission to draft the legislation to the point that we actually got it through. It was a very long time, and as I say, we're now 10 years later, and we're going to have to re-engage with getting that legislation changed. And I'm not anticipating any results on that process in the next 3 to 5 years. So there are, as I say, there are just some hurdles in terms of certainly from our point of view of who we are and what our mandate is, that means that we're going to have to be creative in order to find ways to develop standards that would allow us to move away from individual adequacy findings, which I agree are limiting and certainly very difficult to implement, again, from our point of view.
Thank you. I mean, one idea that is interesting, I think, is to create a sort of a free data area within the African Union. That has been discussed, and South Africa has been defensive a little bit in this sense, as well as in its participation in trade agreements that deal with data governance issues. But I head over to Katie for her input on this.
Thank you. When the U.S. is engaged in these multilateral efforts, which I'm a huge fan of, the U.S. is generally focused on practical, sustainable solutions and solutions that are going to work and be able to be implemented really on the ground when we're trying to identify these commonalities and the data protection privacy principles that apply across different legal frameworks. Really focused on, as occurred in developing the OECD Government Access Declaration and Principles, focus on an evidence-based approach. So really looking at what the laws are in our like-minded democratic rule of law countries, and finding those commonalities and getting those documented and agreed upon as setting baseline principles that can be followed by other like-minded countries. I absolutely agree with everything said about the CBPR forum. Now it's gone global, and I think that's terrific and really provides a good model that can be built off of in other, by other countries as we're looking at really making it global. We also talked about the OECD, Council of Europe, Second Additional Protocol. In each of these forums, there have been multi-stakeholders involved, and then also an evidence-based approach looking at what the laws are now and how organizations can find those common principles and implement them. I can't believe I forgot to mention the data privacy framework between the US and the EU, the replacement of the Privacy Shield. It sets forth unprecedented commitments by the United States with more robust safeguards, more robust oversight, and a new independent binding redress mechanism. So I do think it sets new expectations of the data protection privacy rules that could work in other contexts. I don't mean to call them rules, just sort of provisions and practices. Maybe practices is a better word. Practices that can work in different countries in the national security law enforcement space for protecting privacy. So anyway, I am very encouraged by these different multilateral efforts, and I think the multilateral efforts are really the ones that are going to help organizations with their international data transfers. So thank you.
Thank you, Katie. I was just teaching today about the transatlantic privacy framework, and I'm grateful that you see it as coming along nicely. I just recommend reading the 167 pages of the European Commission, and yeah, it looks complicated on the EU side, but maybe Nele can follow up on this as a EU member state as well.
Thank you. Yeah, it won't be easier, I would say, because besides the GDPR, we're going to have a Data Governance Act, we're going to have a Data Act, we're going to have an AI Act, and so on. So I would say that to make services across borders, it depends on the standards and from the data collected. And I saw how hard it was to make, a health data platform to exchange data, health data between member states. I don't know how many of them are connected with that. Finland, Estonia, maybe Spain, maybe Portugal, I don't know. But it's not so easy as it looks like, because for example, in Estonia, we are collecting health data in standardized way already from the 2009 in health information system. And if in the beginning there were 4 documents, then right now there are, 30 maybe. So between INIXI health platform, we are exchanging just medicine prescription and summary of the health. So it's not so easy as we want to. But I think that the good example is the regulation of the COVID certificate, and data exchanging in digitalized way, and we can ask. We had proof of vaccination before, so-called yellow certificates on the paper, and now we have it in different devices with a QR code. But how it was possible, we can ask. But I think that we all needed some solution, and we agreed very quickly in the crisis how to exchange and what kind of data and how to control the data. But to summarize my thoughts, maybe this is not just a willing to do something. I'm just like a person. I'm going to go to Austria to skiing. There will be some kind of accident. I'm going to be in a hospital maybe, and I want to get a good service. I want the doctor to see my data in Estonia to avoid the risks. So this is not just a willing, but this is a question of the good services also, because the data is in somewhere to avoid risks. So, thank you.
No, thank you. I think this case studies are quite important to get a sense of how this actually works. And you mentioned also rightly that the EU regulation is evolving. We're going to have a Data Governance Act, which on the one hand is going to, support data sharing, which is great. As Bojana mentioned, this use and reuse of the data will be possible. But also we might see protection of non-personal data, which can also then impact all the mechanisms that we have for cross-border data flows. So maybe there are some solutions coming from the UK in this regard.
Well, there are certainly some things happening in that regard in the UK. I think we're in a very unique position, I guess, globally these days, which is interesting. I think I think Bojana actually took a lot of the words out of my mouth with her response. I was going to touch upon some of these issues around standard contractual clauses, binding corporate rules, and the fact that as a country, the UK is having to reach out and strike bilateral data bridges, as we call them, formerly data adequacy agreements. Again, we're working in an imperfect kind of situation here where we are effectively deploying, what is essentially legacy, notions of how privacy and kind of rules will work in a data context, which is again, developing very, very quickly. And so I think it's worth again, kind of just dwelling on the situation that we're kind of working with here. I do feel though that there is a kind of an interesting way forward, as has been alluded to by others on the panel. I think what we're seeing is some interesting convergences and some interesting situations arising where different regions, different countries are starting to proactively put in place mechanisms and have discussions around workable ways to put in place governance that will be fit for purpose and will enable those kind of multilateral agreements to take place. Maybe not now, but certainly in the medium to long term, you can see the potential for that. And I wanted to kind of just again say how proud we were in the UK to be hosting the most recent CBPR forum, which took place a few weeks ago here in London, and how interesting and vibrant those conversations were around kind of establishing what those mechanisms might end up looking like. And so again, very, very interesting to kind of see the kind of kernel of an idea beginning to kind of take root and really kind of develop. So that's been really kind of encouraging to see. And I think, in terms of the way that the kind of the mechanisms that we're seeing at the moment in place, I think, again, we're seeing some very interesting deployments around various, as we mentioned already, kind of guidance from the OECD. We're seeing some very interesting kind of discussions happening at a kind of a global level. I think we are seeing a bit of an emergence of a twin track situation, though, which is very interesting. Again, given the UK's position, kind of not quite as a full member of one block or the other, which is this kind of again, we mentioned the DPF and the data protection framework. We're currently working with a bill here in the UK where we're looking to try and make some tweaks to our own data privacy, data protection regime. The data protection and digital information bill is currently working its way through our Commons. And so hopefully we'll be able to kind of, I guess, lead the way in terms of making some tweaks to the current situation, which may result in some very interesting and hopefully some very positive outcomes for businesses and also for individuals whose data is being used in that kind of cross-border context. So yeah, watch this space. Thank you.
Thank you, Sam. I just have one sort of more concrete follow-up question. So in the pursuit of this more open, more liberal data policy in the UK, also in trade agreements, like becoming a member now of the CPTPP, do you think that this might have some sort of implications for the renewal of the adequacy decision with the European Union?
That's a great question and not one that I can fully answer, unfortunately. I think, look, the way we see things, we're obviously, we take it very seriously. The adequacy agreements that we have with the EU is very important to us. So we're obviously very conscious of that in all the decisions that we make. But the decisions that we're making are proportionate and are designed to make things easier for individuals and make things easier for companies and businesses trying to operate in a cross-border context and an international global market, which is, again, very fast-moving. So I can't speak to that specific issue, but what I can say is that everything we do is taken on balance. Thank you.
Thank you. Very, very diplomatic. I think
Mira, can I
yes,
comment
please.
on this question?
Yes,
Sorry, just very briefly. I just wanted to comment on this question of adequacy. Look, we've had a couple of examples where the EU has granted adequacy decision to Japan and to South Korea. Both countries are signatories and participate in CBPR. And at this point, EU has said that these countries are adequate for European data transfer, subject to further protection of standard contractual clauses when the data is flowing from those countries onwards based on CBPR. So it's not impossible at all to imagine this kind of bridge the way Japan and South Korea are done, but also it's not impossible to imagine that if CBPR were to be upgraded and if EU was to engage in this discussion constructively, which I hope they will want to do, then under GDPR you could have a recognition of a foreign certification, and then you can put additional criteria if Europe really wants to have it. So I think there is absolutely the way forward where there is a will, whatever the saying is, we will get there, right? So all we need to do is just try to get there, and it's going to work. So I don't think the adequacy consideration should be such a bargaining chip, really, in these discussions. In fact, it's not the right way forward. I don't think Europe wants that. I don't think UK wants that. There is a way to make this work on both sides, all sides, in fact.
And can I jump in first?
Yes,
that's okay. I want to clarify one of the points that I was making, which ties into what Bojana is saying. With the data privacy framework between the US and the EU, it does set rules. It is law for the United States from our executive order and the regulations. I want to make that very clear. It is law for us. But it does set forth some expectations around national security use of data. And it does contain a bit of reciprocity because the Attorney General has to designate another country or regional economic integration organization for the organization or the other country to be able to leverage the new redress mechanism. So the bilateral adequacy decisions are complicated and do raise a lot of issues. But I am glad, though, and I'm really optimistic that the new framework is going to meet the needs of the European Court of Justice and also European member states.
No, thank you. I'm glad that both of you are very optimistic and looking forward. Bojana mentioned some countries, New Zealand as well. New Zealand, member of the CPTPP, RCEP, and at the same time having a new agreement with the European Union. However, I was just thinking in this, there is always this political angle, and I think sometimes, the European Parliament is often specifically preoccupied with the position of the UK, which has to do with politics. Okay, so I think we can sort of have a little bit of a more forward-looking last couple of questions. I will combine a couple of questions that I had planned to ask. So on the one hand, do you think that some of the regulatory answers that we are looking for might come from technology? You mentioned already privacy-enhancing technologies, but also artificial intelligence going forward. And then going along these technological developments, how do you see sort of the future of data flows and data governance, let's say in a decade or in 15 years' time? And I open the floor to everyone, again, starting with Bojana and then going to everyone.
Okay. I'll be very brief because I know Nele will want to speak about privacy enhancing technologies as well. But look, I think you're absolutely right. You know, part of this toolbox of solutions has to be technological solutions. And in fact, we at CIPL have started a new project where we are looking and collecting all the best privacy enhancing, privacy preserving technologies, and to explore what is their usability, what are the case studies of them being used, and what legal effect might they have. And here is why I'm saying this last thing. You know, it's all very easy to say, let's do privacy enhancing technologies, but they're very costly, expensive. They need investment. Only the biggest companies are doing this, and you know, governments like health data spaces and so on. So to really be able to invest and put the money, particularly in this economic crisis, we need regulators and policymakers to incentivize adoption of these technologies. They have to say, look, if you adopt these, we will deem you to be an accountable organization. That may be mitigation and enforcement. Maybe we will agree that this is not personal data because you managed to identify to a reasonable level. Even if it's not 100%, it's better than nothing. So I'm really optimistic that they could work for data flows, of course, and I think we've seen some cases already of, for example, big cloud providers using technologies to actually limit access to data. But again, as I say, it's not something you can go to supermarket and buy off the shelf and stick on your computer. It doesn't work like that. It's a serious investment. What is going to be really important, and I'm seeing a lot of that, is that in privacy compliance functions in companies, it's not just about lawyers anymore and auditors. We need engineers who are going to be creating these technological solutions, from federated learning to differential privacy to homomorphic encryption, synthetic data. These are some of the great paths, but they're not answer for all. So I'm interested to hear what your experience
please.
as well.
Thank you so much. I'll give now to the floor to Alison because time is limited. Please, Alison.
I wish I knew what the future of data flows is going to be. I'm not sure what it's going to be next week. It's the area of use of personal data is moving at a speed which I think everybody is surprised by, and which I think is leaving regulators kind of standing in the dust, wondering whether they'll ever catch up again. I think the answers are not necessarily in the technology when the problem is in the technology. I think trying to persuade people that big data is about human rights and it's about the right to privacy and it's about the right to dignity, the right to personality. I think that's a discussion that I don't hear enough of. I hear a lot about technical ways of creating compliance with standards. And I think really the thing that we're trying to do is make sure that people are treated like people, and that they are treated in a way which is respectful and concerns their right to dignity. And I think only if we are really able to find our feet on those issues are we going to be able to meet the challenge of the technology, which I think is going to, as we speak, God knows what's going to be on my Twitter feed tomorrow morning. Even yes, I still use Twitter. Sorry about that.
Thank you, Alison. Katie?
Yes, I do think that the privacy enhancing technologies, many of them have a lot of promise. I completely agree with what Bojana was saying, that they're not going to be the complete solution, because the technology is really one part of governance around the use of data. But there is a lot of potential there that could be really helpful. The Financial Action Task Force and the US and UK had a prize challenge. And they're both looking at privacy enhancing technologies in the money laundering, terrorist financing context. So there's potential there, but within a broader governance framework.
Yes. Thank you. Nele?
I will try it quickly. I wanted to say that these technical solutions don't have to be PETs. They can be, I don't know, we have a consent service, so we already have a service to boost data economy and to create new and innovative services. So you can enter to our state portal. You can choose if you want to send the data from the public sector to the private sector, and you can manage all the consents in one place in very trustable way. But also it can be some other measures like data tracker. We can be using right now opt-in, opt-out solutions. So I think that the key words in the future are trust and visibility. So if I understand like a data subject that what is where is processing, what they are processing, I can access to there in any time from anywhere in the state portal. I can see the data tracker, I can see the logs. So this is a trust and visibility that we want to use these e-services in cross-border services, also in member states. So I think that the measures that have to be alongside with data processing is very important, and the key word in the future will be data quality, because the expectation for the database decisions is increasing, so the quality becomes more important. So it means we have to control them in the beginning, where the starting point is, and yes, we have to change the collection process and standards and so on, but it's not just the PETs, but other ways also. Thank you.
Thank you, Sam.
Thank you. Yeah, so I think again going last every time means the best comments have already been made. But just from my perspective, I think this idea of privacy enhancing technologies is moving us more towards this idea of what I think of as like holistic compliance. So this is no longer about having rules and regulations that are kind of arcane and only really thought about by the legal department, but it's about having, as we say, the engineers considering these things up front, and kind of the policy people working on the ground, or the business leaders, the decision makers in the boardrooms considering these kind of points around privacy, accountability, and I guess the potential dangers of a new kind of approach. So I think that's really the important thing here, and privacy enhancing technologies is a beginning of that kind of taking place. I think that's very important to kind of bring out. In terms of the future of data laws and the future of kind of cross-border data flows, I think again we've touched on it already in this panel, but this idea of a more multilateral approach, something that works in a way that enables business innovation and also protects people's privacy is the way forward. What that looks like, I think is still to be seen, but I think the conversations are happening, and discussions like this one here and the discussions we've been having recently in a number of events and forums have really shown that this is something that's a very live international issue, and one that I'm sure there are a huge amount of goodwill and support in trying to get right. And so I think going forward, that kind of pragmatic, dynamic, and scalable approach to kind of cross-border data flows is going to be the way to go. But we will see what that looks like in due course, I'm sure. Thank you.
Thank you. With 1 minute left, I think we can wrap up the discussion. I think we accumulated a lot of knowledge only within this hour, a lot of insights and perspectives. What I quite liked along all the inputs and all the contributions is there was a line of positivity. So you had some hope and enthusiasm that we are going to find certain solutions. And I think we almost all agree that there is a need to have this sort of a holistic governance solutions, frameworks that involve international cooperation, and technology can serve as some sort of an enabler of certain solutions. And what Katie was also mentioned, this needs to have a more evidence-based policy. I would like to highlight this in the end. And it's often very strange to think that in this data economy, in these data societies, we actually lack the data to come to evidence-based policymaking. This still is quite surprising. So thank you all very much. There weren't any questions from the audience, but I think we had a very rich and interesting discussion. Thank you.
Thank you so much, Mira, and thanks to all of our expert panelists there. And yes, you highlighted there the common thread of optimism throughout that discussion, and not just optimism, but also sort of practical solutions. Really, I mean, we've been talking about this at RAID for many years, as our CEO Matthew highlighted in his opening address this morning. The first RAID conference took place in 2017, and the conversation there was very much about what needs to be done in terms of we're just highlighting the fact that there needs to be a conversation about sort of global alignment on how to deal with the rapid development of technology like digital technologies, AI, and the impact of that on personal data, personal identity, the nature of work, and all the rest of it. But just since we've sort of gone into the virtual RAID conference of the last 2 years, the conversation's really moved on very quickly from sort of what needs to be done, but how to do it, and the scale of engagement from both the public and the private sector, the number of sort of not just privacy experts, but as we were talking about there, engineers within technology companies, but also experts on the regulatory and the governmental side. It's quite overwhelming, really, to see how much is being done and how fast the progress is being made. Not quite as fast as the progress of technology, though.